So before we deliberate, may I ask Armando Benavides to come up and speak? A reminder, the 3-minute clock, and maybe you could put your volume up a little bit higher.
Good evening, board members. Armando Benavides. First, I want to congratulate Trustee Borgioli for being selected the president. I do agree with Peter. I want to add that I think we need to work for our teachers, because our teachers are the ones that are working hard for our kids. So I want to add that we need to work for our students and our teachers, but I do agree with what he says. We have an opportunity to do great work here. I'm really surprised that this item even came up, and that's what I'm talking about: good governance, accountability, and transparency. Those are the hallmarks of a good district. And I think when we start getting closer to that area, the more smoothly this board is going to function. Now, we all know that collectively you took a vote that says we're not going to file that appeal. This firm right here, in disregard of your collective vote, went over there and filed that appeal, which they should never ever have done. And I'm pretty sure that they talked to Mr. Vitano, whoever it is. Then after they filed the appeal, they didn't come back, bring it back to you and say, look, you guys held a vote, but we came up with some new ideas, or we felt that we could file that appeal in disregard of what you guys did. So there's two ethical lapses. One is the fact that they filed an appeal after you collectively voted not to. And the other thing is that after they filed the appeal, they did not come, were not candid. They did not come to you immediately and tell you, look, we are going to file an appeal even though you did not approve it, and this is the grounds why. That way you would have had an opportunity to deliberate the issue. We actually found out of that appeal through third parties. It didn't come from Mr. Vitano reporting it to you guys. It didn't come from anybody else. I have a hard time with a law firm that basically seems to be more working for the superintendent, the collective, you guys. My preference is that we find a firm that's going to start from scratch and is going to basically abide by the principles. They're working for you. And when you take a vote and you say no action, and that law firm decides to go action, that's not a good firm for you. So I say that you go back and find another law firm that's going to be much more ethical in dealing with you as a collective board. Thank you.
Mr. Benavides, as a member of the California State Bar, are you representing anyone? Are you involved in any level in your capacity as an attorney with this case?
No, not with this case, no. I don't get involved with this. Basically, what it was just...
I'm just asking yes or no. Are you an attorney involved in this case on any level?
Excuse me, point of order.
No, it's okay, it's all right.
Right, to ask this.
I do not represent anybody. I do not get involved with anybody. I have not, I do go and look at the files, which is a public document. I do not consult with anybody. This is just my point of view, that we need to get law firms that are going to be working for you and accept your collective
I just want to know if you're representing anyone.
So I think when an attorney approaches the podium, they have a legal responsibility to acknowledge who they're representing. So I think that was just to clarify that they were or weren't representing.
That's all.
Okay, so that does, it's not a Brown Act violation when it comes to talking with somebody at the podium. It's a clarifying question on that particular issue. If somebody is an attorney, they have to, and I'm sure Mr. Benavides, as an attorney, knows that he has to, if he's representing anybody related to the case, he has to state that he represents.
That's a very good point, but that, obviously, he didn't have to make that clarification because he's not. But for us to have the dialogue with the podium is not part of our standard procedure.
So all he was asking, what she was
I asked
asking
a
was a clarifying
yes or no
question.
question.
Do you represent or not? The answer is yes or no, and it could have ended at that.
Okay. So anyway, let's continue. Transparency. You're all about transparency.
Yes, absolutely.
So this item, that's the last of the speaker cards for this item, and the next part is to approve this item. So trustees, yes?
Yeah, I have a question.
Trustee Wolf.
In the materials we received, there was a statement that said the district would also incur additional costs to switch legal firms, because we'd have to pay for the transfer of files and new attorney time to review prior documents. And we know that a lot of time is put in. Do we have any idea what that, do you have any idea at all? I know that's a question that, is not easy to answer, but I'm quite concerned about that. Because it's like, here we are starting all over again. And I'm sure that whatever firm, if there is a firm that comes in and can switch firms, you know, they're gonna start from ground zero.
I don't have the, I don't know if you have historical information. In general, we paid the firm that is terminated or switching, we paid them to prepare the final case file, which is transferred, so we have a cost to them for the final file. And then the receiving ones, all the catch-up, which is usually review of all the documents, in this case, quite lengthy review of the documents and correspondence between the parties. And I don't know how many hours that would be, we haven't yet asked the firm for that information.
How many cases do we have at this law firm? Because it wouldn't just be this one case,
Currently, they handle both charter school and Monty Cohen voices.
and no other, we have
No
no
other
other,
current
like,
cases that
people
you can No people.
ongoing, no
No.
ongoing or historical documents we'd have to come back to.
No, not that I recall.
So, as a trustee, trustee Wu brings up very valid points, and I had not even considered the cost incurred to transfer. But with what Kirsten has brought forward, two cases that we have, I think, given the past experiences with this law firm, and it's public knowledge, yeah, the attorneys were not given clear direction to not move forward, yet they were not given clear direction to move forward. And that's why I pulled this item. I have some grave concerns about spending money from the district on items that is not board approved. And I make a motion that we not approve agreements with Burke, Williams, and Sorensen for legal services for fiscal year 16-17.
I would like to add to this that there was reference made to board action, which did not occur in public. Just to remind everyone, on some specific actions, there was no action because there was no majority related to that. All the points of the case refer back to an original approval of the case. There were two trustees that contacted me individually since the last board meeting to basically present concern or question about the case, and I was able to directly give them a little bit of the history about that, which was not represented by the speaker. The speaker was misrepresenting what occurred, and what had occurred in closed session.
There seems to be information within an email sent to all of us that is referring to things that were only discussed in closed session.
Well, that's not true, because I think, I talked to the voices
Right.
lady.
Out of order.
The voices lady.
So, trustee Rubish, could you just repeat what you just said? Because I didn't get what you meant by that.
Well, I'll speak to you later, you were copied on the same email.
And-
Some
and-
questions
and-
about information that were contained in an email that was circulated to all of us
About what?
about the topic at hand. The retaining of this law firm,
Okay, about the retaining of the law firm, not about,
well, or dismissal of the law
Right.
firm,
okay,
to the contrary, you know, whichever side of it you want to look at.
okay.
Discussion of Burke Williams in an email.
So right now, there's a motion on the table from trustee Badillo. Do I have any second of that motion?
I second.
Just to clarify, the motion is
Sure.
to not approve the offer.
That is correct.
So vote yes.
Correct. So a vote for this motion is to deny the contract between Burke, William, and Sorensen.
Further deliberations?
Absolutely.
So,
Like, yes, and
a yes is to deny. We deal in negatives.
yeah,
So we should always make our motions as a positive.
Yeah.
That is our point. So, we entered into this lawsuit when the board had 7 members and the board gave a majority decision to pursue the action. I want to tread very carefully here. Any subsequent actions after trustee Porter Jensen resigned typically ended in a tie, hence no action. When no action is taken, the world doesn't come to a standstill. The superintendent has an obligation to conduct the business of the board and of the district. He acted in good faith. Because somebody comes to the podium and makes statements that may either demagogue somebody or place an inaccuracy in front of the board is really offensive to me.
Point of order.
It's offensive to me. I'm making my comments. And the fact of the matter is that this board has been represented well by the firm of Burke, Williams, and Sorensen, and that this continues to be a legal issue of he said, she said, pointing at each other, with 6 members coming to 3-3 tie votes in the past. We now have 7 members. My recommendation is that this motion be defeated and that a new motion be entered to approve the firm of Burke, Williams, and Sorensen.
Mr. President,
Trustee Tryon.
I hope we can maybe take some of the emotion out of this and really try to take a step back and really look at what we're talking about here. You know, I was one of the trustees who's been concerned about this law firm, and I have some constraints in terms of talking about it here, because some of the things that we're talking about happen in closed session. And so I can only talk about this philosophically, really. And I can say that I've worked with many law firms as human resources vice president. I've hired law firms. I've also dismissed law firms. When I've dismissed law firms, I have to say that the costs of the transfer were not exorbitant. And we do know publicly that there have been some costs associated with some litigation that this organization, this law firm represented us on. And it's been much more, many times more, 10, maybe 15 times more than the cost of transferring files. My understanding is that we only have one active case or situation with them, which is the Charter School of Morgan Hill, MOU. You know, I think we're close, hopefully we're close to a resolution on that. Hopefully it's not complicated. I certainly hope that the charter school and our board can come together in a very collaborative fashion. It's our sister charter school in the community. And I would hope that if we did go ahead and make a change, which I do recommend, that we could find a very amicable way to settle this issue, put it behind us. There are no other existing live law cases or suits that this firm is representing us on. And I'm very happy to second the motion and really recommend that we go forward and make a change to another firm. As a member of the MIT class with President Borgioli, one of the facts that was brought up many times from other superintendents or the board members around the state is that it is good to make a change from time to time. And in this case, I think without disparaging the firm per se, I would recommend that we cease our relationship with them. We find another competent firm for this kind of work and go forward in a positive way. Draw a line in the sand and go forward in a positive way. Let's put the past behind us, President Borgioli.
Thank you, Trustee Tryon. Yes.
So just to comment on how I'm reading the situation, and, you know, I'm piecing things together because a lot of this predated my involvement in the board. I wasn't in the closed sessions when these issues were voted on. I've had to try and gather what I can from speaking with the superintendent, speaking with others. To me, it seems like there's 2 questions here. One is, did the law firm give inappropriate counsel? And to me, that comes under a question of really, it's not about the appropriateness of the counsel. It was, you know, our superintendent gave direction to the law firm. And so it's really a question of, is that the direction the board wanted him to take? But that's more of an issue of are working with the superintendent, not an issue of the law firm. I also have, having heard multiple sides of the story, I have questions about whether or not, as the narrative has been told in public comment, whether that's actually the accurate portrayal of it. So I think that's one issue, is this an issue of the law firm or is it an issue of the superintendent actions? The other issue I think we can consider here is, does this law firm represent us well? And if we think that they're not doing the best job representing us, does that mean that the cost of changing firms is warranted for making that switch? And so, in my estimation, it seems that it's really the second question, not the first question in my mind. And so that's the one I think is worth deliberating.
Thank you, Trustee Ornett. So I think it sounds like there's a question relative to a no action and what it means relative to what the attorney firm did. So perhaps the superintendent might be able to clear up the no action and what it meant to the attorney firm at that point in time, and that may help. I know there's a motion on the table, but we had some deliberation, and perhaps, especially for the new trustee Ornett, perhaps the superintendent can shed a little light on what a no action means to an attorney firm. And by the way, an attorney firm works for the board, doesn't work for the superintendent. The attorney firm takes direction from the board. If you are involved in any legal matter, for an example, when you go into closed session, they take directions from the board and with input from everybody, including the superintendent. So perhaps in this matter, because it sounds like there was a little emotion, perhaps the superintendent can shed a little light on this subject matter.
Well, credit Mr. Arnett for seeking the information, because we met and I talked about what had occurred during the session. So he was the only one not present during closed session, and I don't want to compromise the discussion during closed session, so I can't expand further.
Okay, thank you, Mr. Superintendent. So we have a motion on the table from Trustee Badillo and a second. Yes, Trustee Burke.
Before we move on, might I answer Trustee Arnett's question from my own perspective? He and I have not discussed this, but your question of has the firm served us well, I believe is what you narrowed it down to. In my humble opinion, after having listened to all the factors in this case and the myriad of nuances and the work they've done with both charter schools, I would answer yes, they have served us well.
Well, I have one more comment to make since Trustee Rubish had something to say. I want to make it clear that without compromising too much information from the meeting, it was made clear during the meeting that in order for the attorney to move forward, he needed 4 votes, a majority. And obviously that didn't happen. So to contradict.
Don't want to discuss what we're talking about.
I understand, but to contradict what Trustee Rubish said, my opinion is that they have not. So that's my opinion. We all have ours.
If I may make one last question, and that
Let
is.
me just acknowledge Trustee.
I just want to make one comment here. On the agenda, it says approve agreements with Burke, Williamson, and Sorensen for legal services for fiscal year 2016 and 17. Could we please, from now on, vote on what that says there rather than on the negative vote? Because I think it throws a wrench in the whole thing. That is what is stated on my agenda. Are we going to or not approve the agreement? It's that simple. I mean, and I think what we have here, we have a negative motion, and we know that if we're voting no, we're voting against the negative motion. If we're voting yes, we're voting for the negative motion. but that's not what it states on my agenda.
So that being said, I'd like to amend my motion. Thank you for clarifying that, Ron.
Trustee Dillo?
I'd like to make a motion to approve agreements with Burke, Williams, Sorensen for legal services fiscal year 2016-17.
Thank you.
Can you repeat that, please?
Yes.
It's the title of F1E.
You're making a motion to approve the agreement. Okay, thank
Yes.
you. Need a second?
I do need a second. If you amended the motion, I need a second on that.
Second.
Trustee Rubish has seconded the motion. Can, I have, yeah, call for question? How do we put that?
Call the question.
All in favor?
Aye.
Aye.
And any opposed?
Nay.
Nay.
Let's do a roll call.
Okay.
So that we can-
Okay, so, as per the superintendent, and thank you trustees and audience for your patience on this, we need to do a roll call, for this particular vote. So, may I start with trustee Rubish? Yay or nay?
Yay. Yes,
Trust-
I vote to approve.
Approve, right, we have a positive, motion going forward.
But
That's
let's
an
use-
approval, that's an approval of
Of the
the
contract.
continuation of the agreement with
Yes.
this attorney firm.
Yeah.
Let's use the words aye or no, because yea and nay sound too.
Yes, I approve.
Yes, you
Vote
approve.
to approve the contract.
Thank you. Trustee Gerard?
No.
Trustee Benevento?
Yes.
Trustee Wolf?
Yes?
Trustee Padillo?
Nay.
Trustee Barnett?
Yes.
And I am a nay.
So the motion carries.
So the motion carries forward 4-3 for approval of the agreement with Burke, Williams, and Sorensen. So the next item on the agenda